Without truth, there can be no justice.
Ladies and gentlemen of the jury, have you reached a verdict?
We have, Your Honor.
Speak out. Ask those questions. Demand that truth.
Hi everyone, and welcome to episode 33 of Truth is Justice. On the 18th of July, the Seacrests filed Sandra's reply brief. If you haven't yet had a chance to read it, I encourage you to. It isn't very long, 41 pages in total, only 32 pages of relevant text. And it isn't difficult reading. It's written in an almost conversational way, so easy to quickly absorb. And it makes for quite entertaining, or more accurately, amusing reading. I'm not going to give an in-depth critique of the whole document, but what I will do is share my thoughts on several different parts of it that I think will give you a feeling for how it will be formally received. My first impression on the first read-through was that it had a bitter, almost resentful tone to it. Now, I don't say that necessarily as a criticism. Maybe that was the tone they intended and the message that Mr. Seacrest and Ms. Seacrest wanted to convey. As to what specifically gave me that impression, well, here are some of the lines that struck me as, they informed my opinion about the tone for various reasons. This is to quote from the brief. Faced with the daunting task of explaining how any rational trier of fact could have justly concluded on this record that it had proved beyond a reasonable doubt Sandy Malgar's guilt. And another. The state cannot argue with a straight face that in a legal sufficiency of the evidence review, the contrary is proven when it offered no evidence whatsoever on the subject. And another. The claim that the crime scene may have been staged is a desperate one. And another, the typical response was to blow it off and do what they did best, nothing. And another, as for cleaning the scene, the state's argument is dead on arrival. And the last one, not so fast. And that one was a standalone comment. Now I understand that to some, those specific comments will mean nothing, or some people may even be impressed by how it is worded in a particular way. And that's fine. I'm just giving you my take on it. For those of you that are familiar with the Hae-Min Lee case, and I suppose even for those that aren't, if you want to observe some truly exceptional, world-class advocacy, look up Ms. Kate Stetson. She presented the appellant argument for Adnan Syed on the 29th of November 2018 at the Court of Appeals. Ms. Stetson presents the arguments precisely, respectfully, and thoroughly. And I'll stress the respectfully point. There are many ways that she demonstrated respect. Respect for the opposing counsel, respect for the victim, Hae-Min Lee, respect for Adnan, respect for the Court of Appeals, and the justice system generally. There is a reason why she is regarded as one of the very best. So impressive to watch. Now, the Seacrest's brief, on the other hand, I believe it was about as opposite to that as you can get. Now, others will no doubt disagree with me, but I found it entirely disrespectful. Disrespectful to all the parties involved, and in my view, not overly helpful to Sandra. It read like it was a chance for the Seacrests to get some matters or arguments off their chests, rather than effectively advocate for Sandra. A soapbox of sorts, rant a little without providing any real effective legal argument, and most likely annoy the appeals court at the same time. Now, just my humble opinion, but in my experience, that generally doesn't result in anything positive for your client. It just serves to boost your own ego. Now, for those that disagree with me and feel that the brief was positive, watch that clip from Miss Stetson, or actually any clips you can find on her in action. For the Adnan appeal, if you search YouTube, search for Adnan Syed Court of Appeals hearing 29th November 2018, it'll take you to the specific hearing that I'm referring to. And yes, I understand that one was verbal and one was written, but I suggest that anything written by Miss Stetson is just as respectfully worded and just as powerful for the client that she advocates for. There are a whole series of YouTube videos showing her talents. If you're interested, have a look. You will view this appeal brief by the Seacrests very differently after you've looked at those. Before I get into the brief, just one correction to a small detail in last week's episode. I highlighted how the Kroger stop, if made after the stop at Texan Liquor, would have necessitated crossing the busy road twice. That was wrong. It would have required crossing it 3 times, making it even less likely. Of course, the Kroger stop could have been an afterthought, necessitating crossing that 4-lane divided road multiple times. Who knows? Well, Sandra knows, and she could have been asked the questions by Bob, but she wasn't. And just briefly on last week's episode, the general point was this. Yes, it's physically possible for those 2 errands, so to the post office and the Texan Liquor transactions, it's possible for those 2 errands to have been performed in that time frame. But if it was, it says quite a lot about Sandra's condition that day. But more importantly, it isn't clear. The details surrounding it are not clear, and that strikes me as puzzling, given Bob's focus on working out exactly what happened. We didn't have a 30-minute time frame. We had a 10-minute time frame whereby a lot of things had to happen for it all to be completed in that time frame. It is unclear, but it needn't have remained so, if only Bob had asked the right people the right questions. This was a perfectly testable element of Sandra's day. By testable, I mean it could have been reenacted, like one of our members did, and which I described. And then questions could have been asked about the inclusion of the Kroger stop directly to Sandra. When statements had been made claiming that Sandra would often stay in the car whilst Jim went into the shop, Bob could have asked what made that liquor store trip any different on that particular day. He could have asked who went into the post office. If it was Sandra, again, why? Why wasn't it Jim, as we have heard that was the norm? Now, it's been claimed by some that there are so many unanswered questions about this case that should have been cleared up. I suggest that Bob, in the position he was in, with direct contact with Liz, and supposedly in direct contact with Sandra, he should have been able to get answers, but again, he elected to not go down the difficult but fundamentally right path in seeking the truth, and that's a real shame. So, was Sandra out running errands herself that day and didn't want to tell detectives because she had earlier noted to them that she no longer drove? Maybe. But put yourself in this situation. Your partner has just been murdered, and you are being asked questions about your day by the detectives investigating that murder. Would you seriously have any concerns at that point in time about getting in trouble over driving when you shouldn't have been? I would have thought that would be the absolute last thing on your mind. What you would likely do is put everything out on the table. Now, remember Jim Clementi talking with Bob and how he talked about how interactions on any given day can increase your risk profile. Well, that adds even more relevance to those errands. Now, would Mr. Jim Fitzgerald have thought it relevant that Sandra said she no longer drove, if in reality she was out driving that day? Maybe. Maybe that would have informed his opinion about her truthfulness during that interview. If you're of the opinion that the errands that day are not important, fine. But be aware that those errands, just like the IT logins, are important details that were perhaps consciously left out of Sandra's narrative for a reason. And it is those little slip-ups that can end up being the most valuable to gaining a true understanding of exactly what happened on the 22nd and the 23rd of December 2012. Okay, let's take a closer look at that brief. And for those of you that still see no downside to the crowdsourced reinvestigations that Bob does, after digesting that brief, I think it is likely that you will have a different opinion. The first thing I'll highlight is the particular style employed, the way different people are framed, for example. Notice how Sandra is referred to as Sandy throughout the brief, but Jim's formal name of Jaime is used for him throughout. Now, it is exactly what you will find in most documents of that type in this circumstance. Indeed, it isn't unique to this brief. It was how it was handled at trial, which is exactly what you would expect. Now, I'm not criticising that. I'm highlighting it for this reason. Since involving myself in this true crime sphere, it has become obvious to me that many in the wrongful conviction camp feel that defence counsel is as committed to finding the truth and obtaining justice for the victim, in this case Jim, as they are committed to representing their client. Now that is simply, and I think quite obviously, not true. Mr. Max Seacrest himself addressed that when referring to the irrelevance of whether their clients are innocent. Don't for a second mistake words by defence counsel as being in any way supportive of the absolute truth. Their words, their framing of the case, their approach in painting Sandra in a particular way and focusing on Jim in another way is all designed to achieve one thing: effective representation of Sandra. That is all. It isn't about Jim, or his memory, or obtaining answers to questions. And if there is one massive, what I consider to be a wrong belief held by many in the true crime wrongful conviction sphere, it is that. And whilst it might not necessarily be Bob's personal view, it is definitely the way he presented the Melgar case, suggesting through his treatment and handling of different case material that his audience should take every word, quite literally every word, spoken by the defence team and their expert witnesses as the whole truth. And at best, suggesting that his audience be sceptical of every single word spoken by the prosecution and their expert witnesses. And at worst, suggesting that they view every word the prosecution and their expert witnesses speak as lies. Now think about just how ridiculous that is. On page 3, the brief notes as follows. The state refuses to acknowledge, much less address, arguments advanced in appellate's brief and mischaracterises much of the evidence by omitting crucial facts and testimony, which, in fairness, must be considered on appeal in determining whether the prosecution discharged its burden of proof. I find that to be an interesting statement. As Adam identified on our Facebook page, skip ahead to page 14 of the brief and read specifically about the way Sandra's mentioning of seizures during her interview was addressed by the defence. Specifically, they appear to suggest that Sandra did not make reference to frequency of seizures, suggesting, through its proximity to the aura statements, that the month ago reference made by Sandra was to an aura. Here is how they frame it in the brief. She had been experiencing auras. As she explained, I have auras, signs that tell me I'm going to have one, and it's like memory, forgetful, more than usual. She repeatedly told them about the auras, and that she had one about a month ago. Now, to say that statement misrepresents the interaction is beyond dispute. A simple matter that was confused and complicated by the defence to further Sandra's argument. The reality is this. Detective Doucet asked Sandra a series of clear, simple, straightforward, unambiguous questions. This is how the interaction goes. Detective Doucet: what did you do when you woke up the first time? Sandra: I couldn't move, because I had had a seizure, and so I usually can't move anyway. I hurt all over and my head hurts. Detective Doucet: how often do you have seizures like that? Sandra: I've been getting them more lately. I'm not able to drive anymore. Detective Doucet: how frequent? Sandra: at least once a month, maybe. The auras? I get them all the time. As Adam laid out so well, the narrative offered up by Sandra in this line of questioning is that she was suffering from seizures on a monthly basis. Sandra's neurologist, the neurologist who had last seen Sandra maybe 2 decades before the murder, admits that Sandra told him a different story to the one she told law enforcement. And this is the testimony of Dr. Hershkowitz. So there's a question by Ms. Barnett. And that's opposite of what she told police officers, isn't it? Answer by Dr. Hershkowitz: I don't know if it is opposite. She told them she was having them once a month, and auras frequently. I don't think it's opposite. But she telling the police officers she's having them more often than what she told me. And question by Ms. Barnett: right, which is 2 different things. Answer by Dr. Hershkowitz: 2 different times, that's correct. And the next item, Ms. Maria Melgar's testimony. This is what the brief says. The state's statement of facts totally omits any recognition of Maria Melgar's testimony. Now, does that sound familiar? And the approach, I mean, not the wording. You remember that Bob arrived at the position that Maria likely had very little knowledge of Sandra's bindings, on the basis of her wildly different descriptions of those bindings at trial, and because her physical demonstration of how Sandra's wrists were restrained was hugely problematic for Sandra. Now, specifically, in their brief, the defence makes this statement with respect to a claim that Sandra was not tied up solely at the wrists. And to quote from the brief, significantly, the state offered no testimony to counter or contradict this, nor did it even attempt to go there in its cross-examinations. To borrow some words from the defence brief, the defence in this instance didn't do their homework. Ms. Barnett specifically addresses this with Ms. Maria Melgar, in fact she goes one step further. Ms. Barnett actually asked Ms. Melgar to step off the stand and demonstrate exactly how Sandra's wrists were bound. It was described to the jury by Ms. Maria Melgar as Sandra's hands being clasped together. Now try that at home and see if you can also get your elbows together. It's pretty difficult, right? In fact, to apply a tight restraint up your forearm with your hands together behind your back would be exceedingly difficult. The defence brief continues. Simply stated, there is no evidence from any source which demonstrates that Sandy was not tied up as described by the only witnesses who saw her in that condition. The big problem with that statement is that the way it was described can by no means be described as consistent between Herman and Maria. From Herman's frequent mention of Sandra's hands being tied during his interview just hours after finding Sandra, to Maria's demonstration at trial. If anything, the one consistency is that the bindings were solely on Sandra's wrists, and accordingly, exactly as Ms. Barnett presented it and demonstrated it at trial. Now, incredibly, the defence even doubled down on this point in the brief, noting the following, to quote from the brief. As to the prosecutor tying herself up in the presence of the jury and getting out of her bindings, it was never established that the manner in which she did so was remotely similar to how Sandy was found tied up by Herman and Maria. Now that statement by the defence is just plain wrong. And remember that demonstration by Maria at trial, which Maria suggests as one of only 2 eyewitnesses of exactly how Sandra was restrained, and that's the defence's description. Maria suggests that Sandra was restrained in almost exactly the same way that Ms. Barnett demonstrated to the jury. So skip back and listen to that part again, or read that part of the brief, and try and understand exactly the point that the defence is trying to make and exactly how thoroughly incorrect this statement is. Now, I know it's a shorter episode, but I'm going to leave it there for now and pick up on the rest next week. Now, there are some real gems that are worthy of exploring, including the defence's, in my opinion, absolutely damning handling of the IT logins matter. The dispute suggested by the defence as to whether the knife wounds means a female attacker was involved, which is interesting given some of Bob's conclusions. This mysterious and now debunked claim of a fingerprint on the safe handle. There's the statement by the defence that no bloody clothing was found in the house. And I think this one may have been partially why Bob dropped the neighbour's surveillance video circus so quickly. The defence's claim that there is no credible evidence that Sandra left the home that night. And thank you for listening to Truth is Justice. We look forward to you joining us next week as we continue to set the record straight.